Losing a spouse or a loved one is never easy. You're in shock and distraught at the loss of someone very close to you, and you now have to suddenly worry about funeral services and wrapping up their affairs, all while trying to take time to grieve and ultimately be with family. Unfortunately, due to our line of work, this is a situation we see all too often with our clients. Your first priority should always be to take time to mourn and be with family and friends. Once you have taken some personal time, however, there are at least 5 items to address when a spouse passes away with the trust. Hi, I'm attorney Andrew Bethel, and number 1 on the list is to notify Social Security. If your spouse was collecting Social Security, then the Social Security Administration, or SSA, will need to be notified in order to stop any payments. This is also to prevent the SSA from arguing you were committing fraud by continuing to collect Social Security beyond their death. Oftentimes, however, the mortuary will end up notifying Social Security for you. A word of warning though, Social Security payments are not prorated. This means that if the funds are being directly deposited into a bank account, the SSA will retrieve the funds deposited for the month that your spouse passed away in, even if they were to pass away later in the month. Number 2, file an affidavit with the local county recorder. If both you and your spouse hold real property in your trust and both of your names are on title as trustees of your trust, something that is likely to occur, an affidavit will need to be filed with the county recorder in order to update their records and remove the decedent's name from the titling. This applies to property held in joint tenancy as well. Filing the affidavit will be required in order to do just about anything with the property down the line. Refinancing, selling, reverse mortgaging, what have you. A certified death certificate will be required in order to file the affidavit. So we recommend requesting multiple original copies at the onset in order to prevent any future delays or headaches by not having any of those on hand. Number 3, have an appraisal done of any real property held in trust. While not required to be done at the date of death, an appraisal done around this time will be helpful for future tax purposes. The reasoning is that if or when you decide to sell the property during your lifetime, capital gains will need to be calculated from the sale of the property. Upon the death of the first spouse, half of the property receives a step up in basis to the fair market value as of the date of death. This reduces your eventual capital gains, if any, meaning that you ultimately pay less in taxes. Oftentimes, an appraisal is required in case you're challenged by the county or if you're audited in order to evidence the amount to which your yearly basis, or your capital gains basis was stepped up. However, you should be aware that homeowners can qualify for an exemption here in California in order to offset any realized capital gains as well. Where an individual has owned a home for 2 of the past 5 years and resided in the home for at least 2 of the past 5 years, they can exempt $250,000 of capital gains tax. This means that a surviving spouse who continues to live in a home and sells the home years after the death of their spouse, they would need to realize a gain of more than $250,000 on the value of their property before paying $1 of capital gains tax. Even if you, as the surviving spouse, were to keep the home until your death, there is another step up in basis to fair market value at that time. This means your beneficiaries can inherit the property at that basis and sell the home without paying capital gains taxes. Therefore, if you are adamant that you'll never sell your home during your lifetime, then you technically don't need to have an appraisal done upon the death of your spouse. Number 4, update your estate plan. A well-drafted estate plan should have safety nets built into it and therefore remain effective upon the passing of a spouse. Thus, updating your estate planning documents may not be required right after the passing of your spouse. However, it is still highly recommended to do so in order to more easily deal with third parties, banks, and insurance companies being the most difficult offenders here. Documents not reflecting the current family dynamics or makeup are the most common rationales given by third parties as to why they won't ultimately honor estate planning documents, particularly powers of attorney. Now that's a bit hyperbolic, but yes, it is common enough that we would consider it being a recurring issue and a necessity to update those documents. Again, this will not be required for well-drafted estate plans, but you would need to keep a certified death certificate on hand to evidence to third parties that your spouse has passed away, so that attorneys can then, alternates can then act on your behalf. Number 5, you meet with your estate planning attorney. If you have an estate plan and your spouse has passed away, you should have your estate planning attorney review your documents with you so that they may spot any possible issues, help determine what the next stage in your plan should be, and so that they may update their records as well. No one's estate is the same, and therefore everyone will have their own set of issues that will ultimately need to be addressed. Meeting with an estate planning attorney will ensure that nothing slips through the cracks. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here. But don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.